The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Good morning. Court Radio is now in session. Call 215-227-2727. When you've got legal questions, we've got the answers. This is Court Radio. And now here's your host, Dean Weitzman.
Good morning and welcome to Court Radio. I'm Dean Weitzman and it's January 17th and it's a little bit chilly outside. Sit back and enjoy another episode of Court Radio. I'm joined in the studio with my co-host, you know him folks, the one, the only, Saul Langsam.
And a very good morning to everybody.
Yeah. Hey, Saul, welcome back to Court Radio.
Thank you. I hope you had a good New Year.
Absolutely. I'm alive and well and breathing.
That's good.
Folks, if you've got legal questions, we've got the answers. Give us a call at 215-227-2727. That's the number to get to Court Radio. And during the week, that's the number to reach My Philly Lawyer. 215-227-2727. And you know, when Saul's in the studio, we're probably talking about wills, estates, and things of that nature. So if you've got questions about your grandmother who passed away 17 years ago and the house still isn't in your name, today's probably the day to give us a call. 215-227-2727. But, before we get on to our legal topics, we have some things in the news. Let's see, Saul. We have a new coach for the Eagles, or an interim coach anyway. No, he's a new coach. Doug Pederson. What do you know about him?
Not all that much. He's no stranger to Philadelphia since he played for the team and also coached under Andy Reid.
Did he really?
Yes, he was a quarterback coach, I believe.
Okay. Well, we're going to figure him out. He's kind of he wasn't on like everybody's A list, I don't think. But I think most people think anybody's better than Chip Kelly. You know, we were fed up with him.
Except for the 49ers.
Yeah. As they say, there's a dress for every woman or a suit for every man. So, wish them well. Have a good time with the 49ers. They weren't lighting the world on fire this year, so they needed anything to, try to stem their bleeding, and I guess Chip will work just fine for that. The National Guard was called up in Flint, Michigan. The water supply in Flint, Michigan has been determined to have excessive levels of lead, and they're giving out spring water to people. Flint's not a small town. There's a lot of people there. This is a major, major problem. People have been complaining for a year now that the water tasted funny, and the government was, poo-pooing it. No big deal, it's fine. And then after a year, they determined excessive amounts of lead in the water. And excessive amounts of lead, folks, can lead to serious brain damage for adults, but especially for children. It looks like there's going to be some serious litigation coming out of that as time rolls on. We'll be seeing who's responsible for the problem. I don't know at this point, but I can assure you that we're going to get to the bottom of it. If you know folks in Flint, Michigan, who need representation, have them give us a call at My Philly Lawyer, 215-227-2727. Some other things. Walmart's closing 269 stores, and 154 of them are in the U.S. I guess they're consolidating. I don't know, but a lot of people are going to be out of a job on that. And last but not least, and kind of a serious legal issue here right in Pennsylvania, a judge in Pennsylvania struck down a state law that imposed a lifetime ban from employment on as many as 200,000 people with criminal records. We actually had a statute in Pennsylvania that, not for all jobs, but certainly a part of the Adult Protective Services Act was a statute or regulation within the Adult Services Protective Act, which said that if you were convicted of a felony, that you could never, ever get a job in that sector, and that has been struck down as unconstitutional, as well it should have been. We're hoping that 2016, we finally pass the law in Pennsylvania which allows folks to apply for an expungement of misdemeanors that are well in our past in order to get them off the record. Some of our friends here at Court Radio have been working diligently to get that done. Right now, the statute seems to be caught up with folks with the whole budget problem. It's like everything is being put on hold because of the budget. They're using the budget as a scapegoat not to sign off on, good legislation affecting students and schools, and in this case, folks who have had misdemeanors. Anyway, with that, we'll wrap up the news for the day, and we're going to get on to Saul and his wills and estates. Let me ask you a question. You and I were talking the other day about this. When somebody passes away, there has to be the appointment of an administrator if there's no will. Okay? Typically, in a will, that's provided for. But what is the job of an administrator? Do they get more money than anybody else?
No, that's a job where you're entitled to compensation, but there's no. That's not part of the job profile. But the administrator, if no will is left, then under our intestate statute, the statute identifies who would be next in line to serve as the administrator, and that becomes a problem for many, many families. If a surviving parent has passed away and there are children, the law looks at all of the children as having an equal opportunity to serve as administrator, but if there's no communication with the children, or somebody is a black sheep of the family, so to speak, then you run into difficulty. Having the court appoint an administrator becomes protracted and expensive, and it basically holds up the administration of a parent's estate.
What does an administrator do? What's their job? What's their function?
The function of an administrator is to gather the assets that were owned by the decedent on the date of death, gather all of the bills, pay the bills, and then distribute the assets consistent with the intestate statute, which identifies which surviving family members are entitled and what the pecking order is for entitlement.
And what is who gets to serve as the administrator of an estate when there's no will?
Okay, it depends on who has passed away and the degree or the relationship of family members who have survived that decedent. So clearly, if a spouse has passed away and there's a surviving spouse, the surviving spouse under the intestate statute is first in line to take. If there are no spouses surviving, then you look to children. And all of the children are looked upon equally in the eyes of the law. And then there's a pecking order that takes you as far out as nieces and nephews.
Okay. So the question then is, when they can't agree, what's the process or procedure when there's multiple people who could serve as administrator and they can't agree to either share those duties? That's possible, right?
It's not uncommon, and that's why the Orphans Court is busy with petitions for appointment of administrators, because you then have to file a lawsuit on behalf of those who want to serve, giving those who are disrupting the process an opportunity to be heard in court and convince the judge why they should not be appointed.
Okay. All right, we're going to get back to this. 215-227-2727. Let's talk to John from West Philly. Hey, John, how are you? And welcome to Court Radio, bud.
Yeah, good morning, everybody. How you guys doing?
We're doing well, thanks. What brings you to the show today?
I'm getting privacy notices from an insurance company, and it contains the name of people I don't know, and it's coming to an address of one of my deceased relatives. So naturally, I'm interested in why they're sending these to my deceased relatives. So I know they're probably not going to want to give me, a total stranger, a copy of the insurance policy so I can see what it's all about. So I was wondering, how do you go about getting that information if you're not a policyholder or probably not the beneficiary either?
Okay, well, that would probably fall in line with what we're talking about, because if it's coming to a deceased relative's home, addressed to the deceased relative, then
No, it's not. It's not addressed to the deceased.
Okay. Who's it addressed to?
I have no idea who these people are.
Okay. Well, then you probably can't get it. If it were addressed to your deceased relative, I could say, all right, you raise the estate for the deceased relative, and through that process, you could petition the court for a subpoena to get the documents that your deceased relative may be a beneficiary of. But if it's coming to some name you don't know, maybe somebody who previously lived at that address, or maybe they have the wrong address, I'm not sure there's any nexus or connection between you or any family member of yours and that policy. And until you could prove there was some sort of connection, I don't think you would have the authority to request the court to give you a subpoena in that instance.
Yeah, that's what I would think, too. But there was, way back when the relative died, we did find an insurance policy that someone else had made her the beneficiary of that we just happened to find. So I'm figuring these are probably the same situation, that the deceased relative is probably the beneficiary, but just...
Well, here's what I would do is to write to the insurance company telling them that you're the beneficiary of the decedent and the decedent's address received notice, and could they check their files to see if the decedent, your deceased relative, was a beneficiary under any policies that currently they're looking for.
Yeah.
But short of that, I'm not certain that you're going to get far on this one.
Yeah, that's what I'm thinking too.
But again, I would write to the insurance company, identifying the address and identifying your deceased relative by name and the address, and ask them if there is any reason for you to take this further at that point, and let them do the research. I mean, listen, if an insurance company, a life insurance company, has a policy of insurance and a pot of money, they have to divulge that to the parties who might be entitled to it. And if they don't, at some point it goes to the state. In other words, it's never going to be, the insurance company's never going to be able to ignore it and just keep those funds for themselves. They know that. So it's going somewhere, and they'd prefer it to go to somebody rather than to the state. So if you give them some information and they can identify it, they will get in touch with you and show you why, the connection. And then you may have to raise the estate for your deceased relative. You may have to petition the court. You may have to give us a call. But they don't have an incentive to hide from you.
All right, sir.
All right, John, take care. Thanks for calling Court Radio, buddy.
Thank you.
All right, have a great Sunday. 215-227-2727. So we have multiple parties vying for it. How do you avoid that?
You prepare a will and address your assets and identify those family members that you wish to inherit.
And also serve as the administrator.
And you identify the executor in a written document.
Right. So there's a different name, folks. When you have somebody who's appointed in a will document, they become the executor or executrix, depending on male or female, versus the administrator. Okay, an administrator is somebody that the court appoints. And a executor is somebody that the deceased, before they pass, appoints in their will.
Right. Well, the administrator, if the administrator can establish his or her relationship to the decedent, and under the intestate statute, that individual would have to be accepted as the administrator for the estate.
Yeah, but I guess I was referring to circumstances where there's multiple parties who could serve equally as administrator, and at some point the court needs to get involved if they can't make that decision themselves and appoint one of those multiple parties.
That's true. That's what we do see when there's no cooperation among family members.
Okay. The interesting thing is when you create a will, okay, you appoint an executor. Folks think, and I've seen this multiple times, when sometimes their family member creates a power of attorney, and the power of attorney document is signed and appoints, let's say, a child as their power of attorney. They think that survives death, and that when they die, the child will become the administrator or the executor.
Well,
Does that work?
It does not work. The power of attorney is a very legitimate document, but the power of attorney only speaks when the giver of that power is alive. Once the creator of the power has passed away, then that document is no longer in effect.
Right. So, folks, if what was created for you is a power of attorney, that works as long as the person is alive, whether they're competent or incompetent. A general and durable power of attorney will survive incompetency, but not death. So once that person passes, if there's no will in place, your powers under the power of attorney are over.
That's correct.
All right, let's talk to Lynn on line 3 from North Philly. Good morning, Lynn, and welcome to Court Radio.
Good morning. How are you?
We're well, thank you. You know, see, people like you fake me out, because for sure I thought a woman was going to answer this phone, and here you are with your deep, deep radio voice. You scared me there for a second, Lynn.
Well, as I listen to you guys every Sunday morning, and y'all just help me out in my business every single day. And now I'm really calling on you guys because I got a real serious issue. I'm a funeral director in North Philadelphia that did a funeral through a state agency for an elderly gentleman with no family and no will. He has a few dollars stuck in the bank. I presented a funeral bill and a death certificate, and the bank has given me major pushback saying that I need to get a short certificate.
Yeah.
And I explained to the bank that there is no family members to open up an estate. There is no one that is willing to administer his estate.
Well, as Lynn, as a creditor of the estate, Saul, can he effectively open an estate?
I don't believe so. He might be first in line administratively once the estate is open.
Wow, so he's in a situation where if he can't identify a family member, well, then can't you have a lawyer appointed as the administrator?
You're going to have a real good reason to convince the court, because just because nobody steps forward doesn't mean that there aren't heirs out there who might rightfully be entitled under the statute. I don't think the courts are going to expose themselves or order a distribution of monies just because a creditor, whether it's a funeral director, whether it's a hospital bill, is knocking on the door. It becomes a very difficult situation.
How much is in the bank, Lynn?
About $5,200.
Okay.
And how did you become privy to that information?
Well, the state agency that handled his care forwarded me the documents ensuring that there was enough money there to satisfy a funeral bill. And he did have a girlfriend. We did establish a girlfriend. But again, she's not a family member, and they were not common law in terms of, Pennsylvania does not recognize common, but we can establish a relationship based on the letters and some of the things that they did together. So actually, good at this. Mm-hmm.
Pennsylvania does not currently recognize common law, but in the past, they recognize, if this relationship goes back, like a decade, they recognized common law marriages then, and they grandfathered those folks in. So if I'm not sure that they are common law, but if they were common law spouses and it goes back far enough, then you may be able to get her appointed as the putative spouse.
Okay, with that being said, we could open up the estate through her.
You could, if they were common law and grandfathered in prior, if their common law relationship existed prior to the change in the statute, then you could have her appointed as the common law spouse, and then you could get paid. This is... Go ahead.
Now, let me ask you a question. A strong letter from your office, will that move the bank a little bit to realize that the money that is sitting in the bank, the funeral home is entitled to cover his final expenses, and that's the first thing that comes out to the estate?
Yeah. Well, the answer is no. That's
you still got to be my hero, man. You got to help me out.
That's the quick answer. But you know what? I am saying to you, I'm not giving up on the $5,200.
No, neither am I.
So I it's sitting there, and I would try to raise an estate through the girlfriend. And you're telling me this girlfriend, this possibly common law wife, doesn't know of a single solitary individual who's a relative of this deceased?
Well, what had happened was he had a twin brother, and when his twin brother died a bunch of years ago, no one showed up for the funeral but him. And after that, he became very estranged from the family to the point that he didn't have any children. His twin brother didn't have any children, and they were the younger members of the family at the time. So consequently, over time, he never talked about anyone, and everyone that was around possibly all died. I think the gentleman was like 78 years old.
Well, Lynn, I think that the common law spouse would be giving good testimony in court about the fact that there is no other family members that he had any relationship with over the last, 10 years or more. And that might, be important to the court to hear that.
If you can establish that she is, in fact, the common law spouse under the intestate statute, she's first in line. And if you can't establish the existence of children, in essence, you could take the entire estate.
Right, but his bill would be paid before her taking of it, but she'd have a vested interest in pursuing this as well. And by all means, give us a call during the week at 215-227-2727. Saul will be happy to work with you to try to resolve this sticky wicket.
Thank you so much. I appreciate it.
All right, take care, Lynn. Thanks for calling Court Radio. Hey, Lynn. Stay on the line, sir. I'm going to have Monica get your address, and we're going to get you a Court Radio T-shirt.
That'd be beautiful. So looking forward to having one.
All right. Folks, if you've got legal questions, we got Saul Langsom in the studio answering questions about wills and estates. We probably have the answer. 215-227-2727. Let's talk to Bob from Sharon Hill because he's a favorite from Court Radio. Hey, Bob, welcome back to Court Radio.
Hey, how you doing? Never left. I listen to you.
I
Sometimes
know.
I like other people to get their questions in.
Well, we got, when we see you popping up on the line, we got to try to reach you. So, what's your question today, Bob?
Okay, you sort of started talking about it, but I have to ask you. If you just got finished saying that power of attorney doesn't mean nothing after the person dies.
That's correct.
And I've been waiting for a couple of weeks to ask you this question. When you're taking care of someone for like 2 or 3 years, and they do have a sibling, and you want to get power of attorney, how do you go about getting that? And when you do have power of attorney, like the person doesn't have no assets or no will or nothing like that, But the power of attorney, the way you just was explaining it, there's no sense in trying to get it.
Well, listen, if you're taking care of somebody who can't take care of themselves and you need to write checks for them, cash their checks, deposit their checks, any of those kinds of day-to-day activities, the power of attorney gives you the right to do that legally, and all banks and institutions would honor it so long as the person were alive. Once that person dies, the power of attorney dies with the person, and you need to have a will in place. If there's a child or a sibling in the picture, the person who's giving the power of attorney can disregard those folks. He can give a power of attorney to a complete stranger or to a friend and ignore his family. That's his or her right to do that.
We can't lose sight of the fact that the person giving the power of attorney has to be competent, okay? Because there are many instances with elderly family members with the early onset of dementia where they may not be considered sufficiently competent to understand that they're giving somebody a power of attorney.
Yes, and Saul brings up a good point. You must have a competent person when the power is entered into. But presuming they're competent, they can ignore their siblings, sisters, brothers, aunts, uncles, and children and say, hey, I want to give it to Bob in Sharon Hill. And that competent person enters into a power of attorney giving you the right to handle their business affairs and make decisions for them involving their medical care, etc., and you become their power of attorney. When they pass, it goes. Go ahead.
But see, the problem is, I already do that. You understand?
Well, you do it, but you do it without the legal right to do it. If you want the legal right to do it, if you don't want somebody to come in and say, hey, what are you doing? You're not him. Why are you, again, yeah, sure, we do a lot of things in this world that we do, and we do it for the right reasons, and nobody says anything. But I'm telling you that legally, you have no right to sign his or her checks or deposit their funds or, enter into contracts or any number of things. If God forbid they get sick and you go to the hospital, you don't have a right to make decisions affecting them unless you have a competent and legal power of attorney. And so, yes, you've gotten away without having to have one up till now, and you may continue to do so, but I'm telling you is that gives you the legal right to. Bob from Sharon Hill, you're silent as a church mouse. Thanks for calling Court Radio. Thanks for calling Court Radio, Bob. Have a great Sunday. There he is. Yeah. The answer was so good. It was such an on-point answer that I silenced him. 215-227-2727. Hey, we hear that we accidentally hung up on Lynn. So, Lynn, if you're still listening, which I'm sure you are, give us a call back and we'll get your address for that T-shirt.
Dean, I want our listening audience to know that we do prepare powers of attorney for our clients, and our fee is just $250.
Guess what? That's the same fee we charge for a will.
That's what we charge for a simple will. That's correct.
Wow. Okay. What's a simple will? Can you give me a simple answer for a simple will?
I can give you a simple answer for a simple will.
Because you got a minute and 26 seconds.
Gentleman prepares a will document to survive by a wife and 2 children. A will is prepared, let's say, leaving everything to the wife, and if the wife happens to predecease, then everything goes equally to the 2 children.
Okay. So if that's a simple will, what's a complicated will?
Complicated wills involve, let's say, minor children under the age of 18, where you have to create trust language in the will document because a child under the age of 18 probably lacks the capacity to be able to handle funds that he or she inherits. So one will usually name a trustee to assist that child until the child reaches the age of 18, which is majority in Pennsylvania.
Okay, there you go, folks. If you were ever wondering what the difference is between a simple will and one that isn't, there you go. If you have minor children or you have children who are incompetent, and they're adults, and you don't want to give them all the money. You want somebody to handle it for them. You need special language in the document that creates a trust and that the money goes into and then gets dished out little by little over time. Folks, Saul and I are going to continue to be here to answer your questions, but we got to take a break. We'll be back in 2 minutes.
Car, truck, or motorcycle accident, you know what matters. Being able to afford medical care, providing for your family while you're out of work, knowing your rights, and getting just compensation. These things matter. That's why your attorney matters. I'm Dean Weitzman. If you've been injured in a motor vehicle accident, My Philly Lawyer will fight for you. Call 215-227-2727. My Philly Lawyer, when winning matters most. If you or a loved one has been the victim of a medical mistake or misdiagnosis, you know what matters. Getting proper care matters. Providing for your family matters. Your attorney matters. I'm Dean Weitzman. For more than 30 years, My Philly Lawyer has been holding hospitals and insurance companies accountable for medical errors. Let us fight for you. Call 215-227-2727. My Philly Lawyer, when winning matters most.
If you have legal problems and need answers, call My Philly Lawyer's Dean Weitzman first at 215-227-2727. Whether it's personal injury, medical malpractice, birth injury, or more, Dean is ready to fight for you and the compensation you deserve.
I'm Dean Weitzman. Facing any kind of legal or medical challenge can be overwhelming, but you don't have to go it alone. Call 215-227-2727. My Philly Lawyer, when winning matters most. If you've been in a car, truck, or motorcycle accident, you know what matters. Being able to afford medical care, providing for your family while you're out of work, knowing your rights, and getting just compensation. These things matter. That's why your attorney matters. I'm Dean Weitzman. If you've been injured in a motor vehicle accident, My Philly Lawyer will fight for you. Call 215-227-2727. My Philly Lawyer, when winning matters most.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back, folks. Court Radio listeners, it's Court Radio, and I'm Dean Weitzman, joined in the studio with my co-host, the one and only Saul Langsam.
And once again, good morning to everybody.
Welcome back to Court Radio, Saul. You know, when Saul's in the house, we're probably talking about death. Well, Dr. Death. Wills, estates, trusts, things that you have to have in place.
We talk about inheritance. That's positive.
Listen, Father Time wins every battle eventually.
Yes, you do. You don't take it with you.
Anyway, you know, I got to take this call, though, because this is an interesting topic for me, and it's got nothing to do with wills and estates also. Eugene on line 3. Hello, Eugene. Oh, Eugene.
Hello.
Hi.
How are you?
Good. You're live and on the radio. Can I call you Eugene, or do I have to call you Gene, or what?
Gene.
What? Gene. All right.
Call me Gene.
Call you Gene. All right. Gene, I'm Dean. Hey, welcome to Court Radio.
Thank you.
You know,
Listen.
I know.
Go ahead.
I know you're calling. I'm going to make it. I'm going to shorten it for you. You're calling about an Uber question. And I want to say that I was down in South Beach last week, and I used Uber for the first time. And it was like smooth as silk. It was so easy to do. I just flipped that bad boy open on my little iPhone app, and 2 minutes later, somebody pulled up and said, "Hey, you Dean?" I said, yeah. They said, come on in, I'm Uber. And it was like perfect, easy, and cheap, too. I can see why the taxi drivers are going crazy. I mean, I empathize with them, but this really works well. So, Eugene or Gene, you're thinking about being an Uber driver, or you already are?
No, I was considering it at some point.
Okay. And you know what? A lot of guys are doing it, and women. A lot of people are doing it just as like extra cash. You know, it's like you can, as the driver, you can flip the app on whenever you want. You become a driver, you work for an hour or two, and whoop, you flip it off and you go eat dinner, do whatever you want to do. It's like, it's seamless. It's, you know, and I'll tell you, most of the guys whose cars I got into, they were intelligent. They spoke English. They rapped about things that I was interested in. You know, it was really a pleasant experience, which is unusual because usually in a taxi, they're not talking to you. You know, they got the earpiece on and they're talking to, you know, some satellite somewhere. I don't know what they're doing, but they're not talking to you. And in Uber, it was just a pleasure. Anyway, Gene, what's your Uber question? I beat this to death already.
I just want to know, what am I responsible for as far as, you know, liability?
Okay.
Something would have happened if, you know, we get into a car accident. Can he come after my assets? Is my insurance going to go up? Should I open the LLC? What should I do?
Okay. All excellent questions. One, you are liable. Okay, so would Uber because you're their agent, but you are liable, you, Gene, as well as Uber. And so your assets could be subject to attachment, but you have to make sure you have a good policy of insurance in place. And I believe, okay, you need to investigate this. I believe that your regular insurance that you drive around in today with whomever, State Farm, Progressive, or whatever towed company you happen to have, because they're all bad, what that company will not cover you if you're using your vehicle as a taxi or as a Uber or as, you know, being compensated for a fare.
That's what I thought.
If you look at the fine language in your policy, it's gonna say that. And so you need to have a second insurance policy. And to the best of my knowledge, and I've only had experience one time, but I'll tell you what it was. To the best of my knowledge, Uber will provide you with insurance. Okay, I don't know what the cost is. I don't know how that works, but they will provide you with a policy while that app is live and you're Ubering. It's going to cover you.
Oh, okay.
I had two clients who were injured by an Uber driver. Okay, they were in the car. There was an accident, and the guy was at fault. And there was an insurance company that got in touch with me, and we negotiated over time. We negotiated a settlement on behalf of my clients for like over $100,000 between the two clients. Over $100,000, which is a blessing because they had serious injuries. And there was $1 million Uber policy in place. Let me tell you, when you get into a taxi cab in Philadelphia, if they even have insurance, it's only $15,000. They got the minimum state insurance. Okay? Right. So God forbid you get seriously injured in a taxi cab, you're in trouble. But in an Uber car, in this instance, in the case that I represented, there was a ton of insurance. Plenty. And so, but you got to investigate that, Gene, before you go live on this plan. But I think Uber will provide it, but your own insurance will not. So make sure you're covered. And if you're covered sufficiently, then I wouldn't worry about it.
Okay.
Gene,
okay.
Thanks for calling Court Radio, sir.
All right, you will. Thank you.
Take care. 215-227-2727. That's the number, you know, when you call My Philly Lawyer. I mean, I don't know if people know how that number came to me in my sleep one day. I thought, hey, I like that number. And you know what it spells? It spells 215 car crash. And it was like an epiphany. I woke up from a dead sleep and said, I got to have that number. And then I spent a year trying to get it. but I got it. I got it. 215-227-2727. Let's talk to Ricardo from North Philly, who's got an estate question for Saul. Hi, Ricardo. Welcome to Court Radio.
How you doing, sir?
If I was any better, man, this drug would be illegal.
Well, my question is, my father died about 15 years ago, and he had a wife, and I think I got two other sisters. Now, his wife died before he did, and he had a daughter by that wife. And his estate, I never found out where his estate went to, but I did hear that she told whoever that he didn't have no other kids, and she took full ownership of the house. How could I find out what to do about that?
Well, that's not an unusual situation where extended family members file a petition with the court and basically lie about the existence of other family members. If you can locate the county or the jurisdiction where an estate was raised, assuming there is one, or if you believe that the real estate was transferred into the name of this surviving daughter, and you can get a copy of that deed, because the deed is a public document that needs to be recorded in order to transfer ownership. You can then reach out to us where we could communicate with this individual to let them know that they, in fact, do not own 100%, but own something a lot less.
Well, I know for a fact that the house is in the Philadelphia area. It's in the Germantown area, so I'm thinking that if I go downtown,
you can go to City Hall. You can go to City Hall, to the records room.
You go to room 154 City Hall. Give them $9 and the address of the property, and they will print you the deed.
Okay.
And with deed in hand, you begin the process of trying to undo what sounds like a fraudulent transfer. And
now, if she sold the house, what's going to happen then?
Well, then you're going to chase the money, because then the house is gone. There's a title insurance company involved. If usually when a house gets transferred, usually there's a title insurance policy in place, and that policy would pay you in the event that you were a true owner of that property.
It's unlikely that there is a title policy in place, because if you're telling me the property may have been sold, a lot of times they sell these properties on a handshake where the only thing that gets recorded is a deed. But the buyer of that property has issues, because the buyer of that property can only acquire the ownership interest that the seller had at the time the property was sold. And if there are other children, potentially like yourself, and others have a percentage interest, that's an interest that was not conveyed to the buyer.
So what Saul's saying is you mentioned two potential siblings from a second marriage, and you.
Right.
So that's three of you. So you owned 1/3 of that house. They can't transfer your 1/3 interest. So the new buyer owns 2/3 and you own 1/3. So, you could take over the basement or something and, put up your love pad. All right, Ricardo, thanks for calling Court Radio. We hope we gave you some information to try to get to the bottom of this, and we thank you for. Yes.
If I get the deed, I can call y'all back.
Yeah, absolutely. You can always call us. Call us at, just ask us what we had for lunch that day. 215-227-2727. You call my Philly lawyer. You will not go wrong.
Thank you. I'll give you a call. I'm going to do that. Thanks
all right,
a lot.
Ricardo. Take care, buddy. 215-227-2727. That's Court Radio, but during the week, that's my Philly lawyer. Let's talk to Rashid from North Philly on line 5, who's got a question about a will. Hi, Rashid. Welcome to Court Radio.
Hello, it's Rashid.
Oh, I see that A here now. See, I talked to Lynn. I thought I was talking to a woman. I talked to you. I think I was talking to a man. Oh, my goodness. I am so confused this morning. Rashida, welcome to Court Radio.
Hello, good morning.
What's your question?
I have a question. It's actually for my fiance. He called me and told me to call you on air show.
Okay.
His mother passed away probably like 12 or 13 years ago, and there was no will. He has 3 other siblings, all women. Now, he was like the black sheep of the family, so when his mother passed away, they wound up taking over the house property that she has. Like, they live in the house now, and they took the car that she was driving. One of the sisters took it, and they left her with nothing but like knickknacks and CDs. They took everything. So his question is, his older sister, well, he's the oldest, the sister right under him. She's not power of attorney, but she's the administrator. She had the paperwork signed. They all got to notarize all that, stating that, you know, she's responsible for or all their mother's paperwork and stuff, you know, for the house and all that. So the question he asked is they're entitled to be living in their house? Because at one point he didn't have nowhere to go and called her and asked her to stay with him, and she told him no. And he's like, well, for one, that's our mother's house, so how you going to tell me no? And she was like, well, I'm an administrator, and I can have the right to tell you no. But he was told by another lawyer that they were supposed to divvy up the proceeds from the house, like sell it. And each sibling is supposed to get a part of it, which that's not what happened. They all the sisters live in their house to this day. It's been almost 15, 20 years now.
Yeah, that too is not an uncommon scenario, and it's a horrible situation where you have, you know, one or multiple children kind of camping out in the deceased's house. And how do you get through that, Saul?
Well, it really becomes messy. The first thought that comes to mind is that the only way the sister would have become the administrator of the estate is if all the other siblings renounced the right to serve as the administrator, which would include your fiance, he being a son. Okay. Now, I'm assuming he signed a renunciation paper in favor of his sister. If he didn't sign a renunciation paper, then you have to take a look at the court papers to see if he's even listed as a child of the decedent. My suspicion is he probably signed a renunciation. That's issue number one. Issue number two is more of a problem that we hear all of the time, and that is family members living in the property when, in fact, there are other family members like your fiance who are not getting any benefit. If he owns a 25% interest in that property, then the sisters living in the property at the very least should get the appraised value of that property at the time his mother passed away and compensate him to the tune of 25%. Plus, if they're living in that property, there's a concept of fair rental value. If they're living in the property and they're not paying any rent and he's not living in the property, then those living in the property owe him something on a monthly basis in place of the rent that they're not paying.
Right. So
Yeah.
if the rental value of the house were $1,000, if that's what you would rent that house for, if we're out on the free market, then he's owed $250 or 25% of the $1,000 for every month that they live there. And so, but it all starts with him getting representation. I mean, he isn't going to do any of this stuff on his own. And and as long as he just lets well enough alone, then the sisters will continue to take advantage of the situation.
Okay. So I'm gonna just tell him to give you guys a call because
I guess
it's been going on for a long time, and he told his sister the same thing, and she's just like not listening. She's like, "Listen, I need somewhere to live, and this is what I've been saying, and this is where we're going to stay at."
Yeah, well, they're going to have to get a mortgage on the property so they can buy him out. So I mean that's another option that Saul mentioned. And it starts with a letter. The court has powers in this circumstance. Like you can demand an accounting, and then the administrator has to come to the court to show how they've been handling the assets of the estate. And if the court doesn't like it, they're going to tell them what to do. So there are avenues that you can force a change in circumstances, but usually in these circumstances, you need to have representation in order to do that. Thank you so much, Rashida, for giving us a call. Have a great Sunday. Thanks for listening to Court Radio, and have a great day. All right.
Thank you.
Saul, our time, unfortunately, believe it or not, is at an end. Can you believe how quickly? Yeah, a break. I'm sorry. Yeah, our time is. You thought, I called you the Grim Reaper and Dr. Death, so I thought maybe you thought your real time, your clock was at an end, but no, we just need to get a break because we've got, people that pay to be sponsors of Court Radio. So, folks, 2 minutes and we'll be back.
If you or a loved one has been the victim of a medical mistake or misdiagnosis, you know what matters. Getting proper care matters. Providing for your family matters. Your attorney matters. I'm Dean Weitzman. For more than 30 years, My Philly Lawyer has been holding hospitals and insurance companies accountable for medical errors. Let us fight for you. Call 215-227-2727. My Philly Lawyer, when winning matters most.
If you have legal problems and need answers, call My Philly Lawyer's Dean Weitzman first at 215-227-2727. Whether it's personal injury, medical malpractice, birth injury, or more, Dean is ready to fight for you and the compensation you deserve.
I'm Dean Weitzman. Facing any kind of legal or medical challenge can be overwhelming, but you don't have to go it alone. Call 215-227-2727. My Philly Lawyer, when winning matters most. If you've been in a car, truck, or motorcycle accident, you know what matters. Being able to afford medical care, providing for your family while you're out of work, knowing your rights, and getting just compensation. These things matter. That's why your attorney matters. I'm Dean Weitzman. If you've been injured in a motor vehicle accident, My Philly Lawyer will fight for you. Call 215-227-2727. My Philly Lawyer, when winning matters most. If you or a loved one has been the victim of a medical mistake or misdiagnosis, you know what matters. Getting proper care matters. Providing for your family matters. Your attorney matters. I'm Dean Weitzman. For more than 30 years, My Philly Lawyer has been holding hospitals and insurance companies accountable for medical errors. Let us fight for you. Call 215-227-2727. My Philly Lawyer, when winning matters most.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Folks, I'm back, and it's Court Radio. It's still Sunday, January the 17th, and I applaud you for listening to Court Radio to this point. You know, if you've been listening, we're joined in the studio with my co-host, the one, the only, Saul Langsam. Hi, Saul.
And a good morning.
Welcome back to Court Radio.
Thank you.
It's always a pleasure to have you. You know, when Saul's in town, he flies in from the West Coast and drops in here for a little show or two. We're talking wills and estates. The guy writes wills for stars all over the world. And for you, he'll do it for $250. A simple will. Simple. Don't get complicated on us, because if you do, we can handle that. But then the clock ticks faster. 215-227-2727. That's how you get in touch with Saul and ask your questions. Usually Monday morning, you're held up in your office. The phone's going like crazy.
They do.
Yeah. And he has patience of a saint, this guy. He'll listen to everything that you have to say, unlike me. Click. 215-227. I love you. I'm just kidding. 215-227-2727. Let's talk to Kathy from Wilmington, who has a will question. Hi, Kathy. Welcome to Court Radio.
Hi, how are you?
Good, thanks. What's your question, dear?
Well, my mother had a great aunt, that passed away over a year ago. She didn't have any children, and she had like between 6 or 7 nieces and nephews. And she left her executor with one of her nieces. And the niece that's in charge of everything nobody has gotten anything that my aunt left to them. And it's been over a year. What could we do about that?
Well, the executor is responsible for handling the administration of the estate, and if the executor is not doing what she is supposed to do, and attempts have been made to motivate her to do so, a petition can be filed with the court for her removal. And
I can't hardly hear you.
I'm saying a petition can be filed by the other nieces and nephews for her removal. She can be removed by the court for not fulfilling her duties as an executrix.
Oh, okay. Okay. So they just have to go to the courthouse and do that?
What courthouse was she appointed as the executrix?
She lives in Virginia, so I'm not sure.
Okay. Well, yes, and you. My advice would be the remaining family members who aren't being treated fairly need to get together and probably retain an attorney in that jurisdiction, wherever the estate is raised. And that is where you want to file the petition to have the naughty executrix removed.
Okay.
All right. Thanks for calling Court Radio.
Thank you.
Have a great Sunday.
Thank you.
215-227-2727 as we round down the hour. Let's talk to Shanita from South Philly. Hey, Shanita, welcome to Court Radio.
Hi, it's actually Tamika.
Oh, Tamika. Okay, well, there you go. I've totally butchered names the entire day. I feel like who was that guy who called Miss Philippines Steve Harvey. I feel a little bit like Steve Harvey this morning, just a little. I don't have his cash though. So Tamika, tell me what brings you to Court Radio today. We got very little time.
Yeah, I'm going through a divorce right now, and the agreement was before we had the divorce that I pay the mortgage. Since I bought the house, I pay the mortgage and all the bills. All he had to do was pay the car note and the car insurance. He dropped my insurance and never told me, and I got into a car accident. What can I do?
Well, not a lot. I mean, if you're the legal owner of the car and it was uninsured on the date of loss, and if you have an agreement that he was supposed to keep that in force, at some point, if it's a judgment against you from that accident, I suppose you could try to take that from him, okay, from his share of whatever he's entitled to in the divorce, if anything.
Okay. Because I do plan on selling my house.
Okay. And when you sell it, does he have an interest in a piece of it?
Yeah, his name is on the mortgage, on the deed.
Okay. So if you end up with a judgment against you and you believe it's because he didn't do what he was supposed to do under that agreement, you could sue him for that judgment amount and take that from the proceeds he would be getting from the sale of the house.
Okay, because my other lawyer's telling me to file for bankruptcy, and I don't think I need to do that.
Well, again, filing for bankruptcy may get rid of that obligation because, as I said, you would take that money back from him, but you're taking it back because you've lost it and somebody else has gotten it. And if your attorney thinks that you can avoid having to give it to somebody else, a bankruptcy might be in your best interest. But again, that only comes from an analysis of your assets and all of the issues. And unfortunately, we're out of time. Tamika,
all right.
Take care, dear. Good luck.
You too. Bye-bye.
Folks, Saul, thanks for joining us.
And I thank you, and everybody have a wonderful day.
We'll see you next week. Same time, same place.